It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
Did you know that parents rank financial literacy as the #1 most difficult life skill to teach? Meet Greenlight, the debit card and money app for families. With Greenlight, you can send money to kids quickly, set up chores, automate allowance, and keep an eye on your kids' spending with real-time notifications. Kids learn to earn, save, and spend wisely, and parents can rest easy knowing their kids are learning about money with guardrails in place. Try Greenlight risk-free today at greenlight.com/Wondery.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my supreme co-host, Brett.
Yes, supreme. Exactly. Thank you, Alice. I think we can end the episode there.
You're my only co-host, so you're first and the last. You're the best
First
and the worst.
among equals.
Well, that was low-hanging fruit there. We are talking about the Supreme Court today, but we talk about the Supreme Court a good bit. But today, maybe a lot of you have heard about it because our favorite Karen,
Favorite Karen.
However you want to say,
Redeeming the name Karen.
Redeeming the name Karen for all Karens. Yep. Karen Reed is up at the Supreme Court. What does it mean? Is everything going to end? Is the Supreme Court going to step in and say, no, Canton Police Department, you will not yet again conspire against innocent Karens across the world? Or are we going to see something pretty rote that's not even newsworthy, but it's newsworthy because of this case alone? We'll find out, Brett.
We will. And it's hard to believe. It feels like just yesterday we were doing our Karen Reed coverage, our favorite case we've ever done.
It was yesterday, wasn't it?
I know. And now we're back. It's going to be a new trial. And I just want to say, I just want to start off with a word of praise for our listeners because we have the best listeners. You know, I've been hanging out on Twitter, engaging is how I'll put it, with some of the Karen Reed supporters. And it just made me appreciate you guys so much because y'all are so thoughtful and analytical. And even when you disagree in really intelligent ways, challenging ways. And I just really appreciate y'all. And I just want you to know that y'all are the Texas Roadhouse of podcast listeners. And that is the highest compliment I can give.
I was going to say, those of you who may not know if that is a put down or a compliment, Brett loves Texas Roadhouse.
I love Texas.
When we used to go to lunch together every day because we worked together and shared a wall, I don't know, 10 out of 10 times when I said, where do you want to go? He'd say, you have to pick because you know I'll go to Texas Roadhouse.
Yeah, that is always my choice. It's the best. If you guys haven't been to Texas Roadhouse, my wife
really
used to travel. We lived in Alabama, but she had to work in D.C. And so she would go off. She would leave on Monday and come back on Fridays. And I would go to Texas Roadhouse every night. Everybody at Texas Roadhouse knew me. I was just I was always there. I loved it. Anyways, that's an aside. Texas Roadhouse is awesome.
That's an aside. Okay. So you are right. Twitter has no filter. People on Twitter have no filter. And so there's been a lot of engagement. If you were to only read Twitter, you may think, my goodness, what are they doing? Retrying this poor woman again. Don't we have constitutional rights? She's already been tried once for murder, manslaughter, leaving crime scene, all these things. And you know what? You can't be tried again because this country is all about no double jeopardy. There was a movie in the 90s made about double jeopardy. It is our constitutional rights that go back before the 90s, in fact, back to the founding fathers. So how can this crooked, conspiring Massachusetts Commonwealth deign to disregard the Constitution of the United States that protects us all equally and try her again for these same charges, Brett? And that's exactly, actually, we're not making farce of that. That really is the argument of many arguments she has, but that specific argument is what she has brought all the way up to the Supreme Court. But before we get there, to get to the Supreme Court, you have to appeal through a bunch of courts, state courts, federal courts, all the things. And she's done that. And what have they done so far, Brett?
They have denied her. Everyone's in on the conspiracy. It's sort of amazing. We did an episode earlier on why this was always doomed to fail. You know, this double jeopardy argument. Essentially, just for those of you who, for whatever reason, haven't listened to all the legal briefs, maybe haven't followed this case as closely as others. So Karen Reed, she had her first trial. It ended in a hung jury. There was an Allen charge, sometimes called the dynamite charge. I think in Massachusetts it has a different name, like the Rodriguez charge or something.
It's the try harder charge.
The try harder charge. It's the
try harder to get a consensus.
Yeah, you guys need to get back there and convict this woman, is what I always think of it as. But anyways, so they did all that. It failed. And the jury sent these very sort of like well-written, poignant notes about how they were morally divided and could never cross that bridge. And so the defense asked for a mistrial. Everybody asked for mistrial. Mistrial is declared. The defense, they don't have time to poll the jurors because they need to rush out to the front steps of the courthouse to declare victory because, they got their mistrial, which is what they wanted. So that's what they do. Well, then subsequently, these rumors start rising up that, in fact, the jurors, all 12 jurors, had agreed in some form or fashion that Karen Reed was not guilty of one or two counts, the second-degree murder charge and maybe the leaving the scene charge. So they were still up in the air about whether or not she got really drunk and ran over her boyfriend. Go ahead.
And it's worth noting, this is all rumor. This was not polled in court. This was not part of the record. We're going to find out. Here's a little spoiler alert. Doesn't matter. But we are talking about this is just what we're hearing from the attorneys, and we have nothing to back this up.
So now the attorneys are wanting to have an evidentiary hearing to probe into what the jury discussed, which is almost never allowed, is incredibly disfavored. There are all these cases that talk about how essentially once the jury leaves the courthouse or even the box, it's just over. Like you can't go back and like say, oh, never mind, we actually reached a verdict for all these reasons. Like I said, we have an episode on this a while ago. Well, that did not stop Karen Reed and her attorneys from challenging the retrial on the grounds that she was factually acquitted, if not legally acquitted. And they had sort of a nuanced approach to this. It was kind of double jeopardy, but it was also kind of just general due process because I think they recognized their double jeopardy issue was a little weak because of all the precedent. So it was more like, okay, fine, maybe we can't get double jeopardy, but this is just so fundamentally unfair that it should be a due process issue that she gets retried. And as Alice said, initially they do what you do, which is you file something with the trial court. Trial court denied it, and then they appealed it. And in fact, they appealed it all the way to the Massachusetts Supreme Judicial Court, which is the highest court in Massachusetts. And as Alice pointed out, unanimously, the other members of the conspiracy, the people on the Massachusetts Supreme Court, denied this appeal. So at that point, it probably should have been over. But they decided to do something really different and interesting. They filed a federal habeas claim challenging the retrial. Now, let me explain how that works, because ordinarily, there's the habeas corpus goes all the way back to the Magna Carta. It's one of the fundamental rights. In federal law, the constitutional provisions for habeas corpus are in statute under a couple different statutory provisions. There's one called 2255, section 2255, 18 U.S.C. 2255. I think 18, actually maybe 20. Anyways, it doesn't matter. We'll just say 2255. So under that provision, if you've been convicted and sentenced, you can challenge your conviction on the principle that there is some fundamental injustice that invalidates that conviction. Commonly, ineffective assistance of counsel is one. So I was denied proper counsel, and therefore I should now be able to challenge this. And that is the standard habeas corpus provision and the way it's typically done. But there's a problem here for Karen. She was not convicted. I mean, I guess that's not a problem normally, but she wasn't
for purposes
convicted.
of habeas corpus.
Exactly. So she can't bring it under, I think it's 28 USC.
28 USC.
So you can read it if you want to. So, but there's a residual provision, 28 USC 2241, which is the broader provision. And it sort of encompasses the general idea of habeas. And you could almost never bring anything under this. But they said, hey, we have this situation where her trial is going to be fundamentally unconstitutional. So we should be able to challenge it now. Ordinarily, you can't do that. So ordinarily, if you're in state court, you cannot petition the federal court to stop your trial.
Because they're different jurisdictions, right? We're all about different sovereignties. Exactly. Different sovereignties. That's why there's no double jeopardy if you get charged for the same set of facts under federal law and state law. We've talked about this in our legal briefs.
We have. And as we've said 1,000 times, yes, there's the supremacy clause and the Constitution is supreme, but we have these two sovereigns. They're equal in power, and we just don't let federal court say you can't try that person in state court. And there's actually a doctrine. It's called younger abstention. We get nerdy now. And the last time I thought about younger abstention was back in Fed courts. Did you take Fed courts?
I took Fed courts. Did I learn Fed courts? I don't know. But
have we talked about my Fed courts experience? Have I done that?
No,
Have I talked
I
about
mean,
this?
no, but please do right now.
So here's the thing about law school. If I had taken law school a little bit more seriously, there's no telling how well I could do. But I didn't really. I really kind of saw it as a 3-year vacation, right? I was like, hey, whatever. You know, what do they call the person who finishes last at Harvard Law School? A Harvard lawyer, right? So that was sort of my position on that. So by the time I got to Fed courts, I was really into Guitar Hero and Rock Band. Really enjoyed it. This was a moment in time, which some of you probably don't even remember, but basically in the mid-2000s, this video game came out where you had this like video game controller that looked like a guitar, and you could play songs on this like fake electric guitar. And it was so much fun. And like for a while, like everybody would play it, like every party, you know, people would play it. And I was really good at it. So I would always do this thing where I'd show up at a party and like, I'd be like, oh yeah, what is that? Oh, Guitar Hero, that sounds fun. And I'd get it and I'd be like, okay. And I would like set it to impossible. And they'd be like, oh no, you don't want to start that. I was like, no, I got it. And then I'd kill it because I was really good at it. I have no musical talent whatsoever, but this video game I was really good at. But at the time, there was this song called Psychobilly Freakout on the game. And for whatever reason, I just could not beat Psychobilly Freakout. So basically, I never went to Fed courts. I went to one Fed courts class when I was on panel because they would tell you, basically in law school, they call on you. But some professors say, I'm going to call on you on this day. So that's the only day I went. All right. So I went that day. I got called on, answered questions, went home. So getting ready for the test, and my roommate and I are both in this class. So he's like studying nonstop for Fed courts. But I'm like,
which, by the way, is one of the meatiest classes. It's like a very important class, right? I
was like, I got to beat Psychobilly Freakout. Like, this is my thing. And I played Guitar Hero. I think it was Guitar Hero 2, just constantly. And it was the night before the final. And literally the night before the final, I beat Psychobilly Freakout. And I was like, that's a good sign. I'm going to do well. When I took the test, got my B+, which is all I wanted. My roommate got a B. And I was like,
that's terrible.
Anyway, so I learned a lot in Fed courts, and I learned about something called younger abstention.
Was that the one day you were on panel?
No, I just, I read the book, whatever. So, and there's a bunch of abstention doctrines.
By the way, every law student hates you.
There's a bunch of abstention doctrines, and they're all weird. There's one that's called like Thibodeau abstention, which applies in like Louisiana, and there's like one that's about oil and gas law, and there's just all these different abstention doctrines. And basically, what they mean is the federal courts are supposed to abstain in those circumstances. And Younger says if a state defendant tries to stop their state trial, the federal courts are supposed to abstain from that. They're not supposed to do it. But double jeopardy is an exception to Younger abstention. So now Karen Reed and her folks, they're going into federal court, and they really have to go all in on double jeopardy because they need the exception. So they go into federal court, they go to district court, and what happened to district court, Alice?
Denied.
They lost. And the judge denied their motion to stay the state trial.
But at the district court level, there's only one judge. So it's easy for one crooked judge to overlook this conspiracy or to be part of the conspiracy. So I thought they were going to lose at the district court anyway, because, of course, that one judge could be bought off. I'm kidding, by the way.
Yeah. And he's in Massachusetts, and everybody in Massachusetts is in on this. So they buy off that judge. So he denies it. They appeal, because why not, right? I mean, they have unlimited resources at this point.
They've already went to the federal courts. They might as well appeal all the way up to the Supreme Court.
All you grandmothers on fixed income who give your money to Karen Reed, I just want you to know it goes to her media empire and her frivolous lawsuit. So I'm glad that you're giving the little money that you have to this woman and her defense team. Congratulations. Now you see what it's being spent on. So she files her appeal to the First Circuit. It goes up to the First Circuit. And what happens in the First Circuit?
Would you know it? These judges are also part of the conspiracy. Denied. They do not buy her argument.
And let me just say this. We don't like to get political in this podcast. But the fact of the matter is that the Massachusetts Supreme Judicial Court tends to be considered a little bit more liberal and pro-defendant than maybe some other Supreme Courts. In most of the district courts,
honestly,
in Massachusetts,
Brett's being really nice. I mean, this is not meant to be political. Massachusetts is one of the most pro-defendant courts. It truly is.
It truly is.
If you lined up all the way they do their arguments, it's like California and Massachusetts.
Yeah, I mean, pretty much, right? In the district court, same thing, because Massachusetts has for a long time had Democratic senators. Senators play a big role in picking district court judges. They're going to want people who are like them. They can stop the president from nominating people if they don't want them. So typically the people who get nominated for Massachusetts courts tend to be more liberal. And typically, if you're more liberal, you're probably more pro-defendant. Karen Reed loses there. The First Circuit, which is the circuit that's like Maine, New Hampshire, Vermont, and Massachusetts, I think. Maybe
Sounds
Rhode Island.
good.
Is Rhode Island in there too?
All the little ones.
All the little states. All the little states up there.
Is Rhode Island part of it? Maybe it is.
I'm not sure. Maybe it is. But those states tend to be a little bit more liberal, a little bit more sort of Democratic leaning. And so the First Circuit tends to be a little bit more liberal, a little bit more pro-defendant. Karen Reed goes up to the First Circuit and she loses unanimously, gets just completely wiped out, asks for a stay of her trial and is denied. So she is just losing across the board everywhere she goes, right? So her trial is impending. We're selecting a jury, and yet she is still pushing this. And she has decided to take the ultimate step to the Supreme Court.
To appeal to the Supreme Court. And we've talked about the Supreme Court before, that when you file a writ, there's like 7,000, 8,000, upwards of 10,000 cases that are filed, but it's a discretionary court. They don't have to take every single case that comes to them. They get to select which cases have merit that they want to listen, or some sort of controversy, or some point of law that is unclear or has never been ruled upon. They look for those types of cases because they are the Supreme Court, and they are essentially, one case isn't really about that case. It's about what that case will then be applied to for all the lower courts. And so they take 80 cases a year, something like that.
Yeah, they take
a very small percentage.
They get about 8,000, 9,000 petitions, upwards more than 8,000. They take about 80. Let's just say 8,000 to make the math easy.
Yeah.
They take about 80. I mean, I didn't do that well in math, but I think that's 1%. Am I right about that? Is that 1?
That's less than 1.
Is it less? No, because 800 would be 10%, and 8,000 would be 100%. So 80 is 1%. Now, 1% that's if it's 8,000. It's less than 1% if it's more than 8,000, and it's really 70 to 80. So it's 1%.
I was going to say, I've always heard the stat. It's less than 1% of the cases are picked, right?
So that's what she's up against. And let me just point out, now, what kind of cases is the Supreme Court taking?
Issues of first impression?
Issues of first impression. And one of the reasons we're talking about this the way we're talking about it is because, just to go back to Twitter, if the only thing, where you got your news was from the Free Karen Reed, Legal Eagles, YouTubers, and everything else on YouTube, you would think this is a serious legal challenge that is being launched here. So that's why we're talking about this the way we are. But yeah, so issues of first impression, issues where there's strong dissent, circuit splits where you have circuits against each other. Circuits are arguing. Cases that went en banc, which means the entire circuit heard it. Maybe it was a close vote. Cases that have been, litigated in all these different postures. Like, these are the kind of cases the Supreme Court's taking. The Supreme Court does not typically take cases where every single jurist from every single court, both state and federal, that have ever considered the issue have summarily denied it. That doesn't typically happen.
And here's why. Because when you have all these judges across the board, not one dissenter, agree, it probably means the law is incredibly clear. Because either the Supreme Court has already ruled upon this area of the law, and there is absolutely no question about it, and the best arguments are brought before all these judges, and 100% of the judges who've heard it not only deny it, but are like, you don't even have a chance because there is no question about what the law is. We're not going to grant you a stay. We're not going to halt your trial because we know exactly what the outcome is going to be going all the way up to the Supreme Court. That's why it matters. It's not that everyone's part of the conspiracy. It's that clearly this area of the law is incredibly clear because either there's no question about it or the Supreme Court has already spoken very clearly upon it. This episode is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game, shifting a little money here, a little money there, and hoping it all works out? Well, with the Name Your Price tool from Progressive, you can be a better budgeter and potentially lower your insurance bill too.
You tell Progressive what you want to pay for car insurance, and they'll help find you options within your budget. Try it today at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states.
Running a business can be exhausting. Building your website shouldn't be. With Wix, you can express your ideas, give direction, then leave the heavy lifting to AI. From site creation to branded content and images. Have fun with the details. Customize what you want the way you want. And manage your whole business from a centralized dashboard with expert AI tools. Build, scale, and enjoy the incredible results. You can do it all yourself on Wix.
Today, the beverage aisle looks a lot different than it used to. America's beverage companies are working together. We're delivering the options everyone wants. In fact, nearly 60% of beverages Americans buy have zero sugar. You'll find more variety than ever, including more of your favorites, now available with zero sugar. You'll also find more sizes and clear calorie information on the front of every can, bottle, and pack. We know when it comes to finding balance, the more choices, the better.
Rakuten is the smartest way to save money when you shop because you earn cash back at over 3,500 stores. Fashion, beauty, electronics, home essentials, travel, dining, concert tickets, and more. Your favorite stores like Lowe's, Levi's, and Nike pay Rakuten to send them shoppers. And Rakuten then passes on a part of that payment to its members as cash back. You're already shopping at your favorite stores. Why not save while you're doing it? It's a no-brainer. Membership is free and easy to sign up. Get the Rakuten app now and join the 17 million members who are already saving. Cashback rates change daily. See Rakuten.com for details. That's Rakuten. Your cashback really adds up.
So we file this petition for certiorari. Now, as Alice said, this is a discretionary court. Supreme Court doesn't have to hear anything it doesn't want to hear, but they're going to hear what they want to.
And also, here's the thing. The courts really are very open to people, even with the discretionary court. Basically, the only thing keeping people from being able to file with the Supreme Court are probably like rote procedural rules. Like you have to bind it in a certain way. It has to go to certain printers. There have to be certain covers and they have to be bound in a certain way with certain colors. Like quite literally, the way the brief looks might get you kicked out because they're like, you didn't follow the font. You didn't follow the binding. That's like the only bar to filing at the Supreme Court. There's no bar. I mean, I think you have to be admitted to the Supreme Court, but to be admitted to the Supreme Court is not an extra test. Yeah. If you are a practicing member of any bar in good standing, you can apply to be part of the Supreme Court bar. So I say this because people are like, whoa, it made it to the Supreme Court. And I'm like, any Yahoo who basically has not been like disbarred can file at the Supreme Court. And the only thing that kicks them out, and I see this with people who are not sophisticated, is they literally get the font wrong on the brief.
Yeah, you have to use, what is it called?
You have to use like two printers, like quite literally there are two companies who print the briefs.
you have to contact the printers early because they're the only ones who do it. Alice is right. And they have to do it in a certain way.
Talk about a monopoly.
And she's right. It has to have, the cover has to be a certain color. The font is like Century School Book or something.
Nobody uses it.
No one uses it. Except
and it's like
Supreme
all
Court.
caps.
And
I might have
the
one.
margins.
Here. Oh, I should have brought one. They're like half. Yeah, basically the paper is like half a sheet of 8.5 by 11.
Most wasted ever.
But they write on only like a third of that paper.
Yeah. The indents are literally like 6 inches on both sides, and then just very narrow column of text right in the middle. That's the way
it's like
they have
if
to
your
look.
grandma had all these requirements for the type of mail she wanted to get. It was like, I don't have good eyesight now, so I need it to be real big and maybe 3 letters on page.
I mean, it's wild, right? But it's all this stuff, and that's the way it is. And when you file a Supreme Court brief, which, we've done because we're awesome. You do. You have to do all this stuff. So that's literally the only barrier, though. The only barrier to
that
entry.
That is our purpose of saying it here, because if you read Twitter, you would think, wow, it's such a big deal to even be able to file there. Our judicial system, for all the faults it may have, is actually incredibly accessible to everyone. So you don't have to be part of a special class, in other words, to be able to file at the Supreme Court. You should get someone who knows what they're doing if you ultimately want to take a case to the Supreme Court, because it is actually a pretty small bar of people who the justices respect and they know how the rules work. But anyone can file there.
And so the way it goes, there's always little indications. Like if you're following this, what are the indications that a case might be granted? So initially, you file your thing, and then some things happen automatically. There are Supreme Court rules that lay out how this happens. The first thing that happens is, so somebody files their cert petition. It is then the other side. So in this case, the Commonwealth of Massachusetts and the people who are prosecuting her, they get an opportunity to respond. If they want to, they can file what's called a bio, a brief in opposition. But they can also say, you know what? We don't care.
Waive it.
Yeah, waive it. And
because briefs take time, and like printing the actual briefs takes money. It's like a lot of money.
Yeah, and then once again, if you do it, you have to do you got to be in the right color on the front, and it's got to go to the right printer and all this other stuff. So you can waive it. And waiving it, I've talked about this before. When I file a brief in an appellate court, I always put that there's no need for oral argument in this case. I don't need oral argument here. This case is easy. It's kind of the same thing. You're like, I don't need to file an opposition. You're not going to grant this, right? So you send that up. Well, at that point, if it's a real case, right? If it's one that the court might actually consider taking, the court will say, you know what? We're going to go ahead and call for your opposition. So you had the opportunity to do it freely, but now we're going to tell you to do it. So then you have to do it. And, there are different strategies for this. Like I remember when I used to do Supreme Court practice, sometimes we would challenge ourselves to keep it under 5 pages. Like just once again, just to be like,
to signal how
simple.
Easy it is.
Right. I don't know why you're making us write this, but if you're going to make us write it, here are the 3 paragraphs you need to know. Get out of our face. Right. So that did not happen in this case. The Commonwealth waived the bio. They were not ordered to respond. Karen Reed also asked for a stay, which is something that will commonly happen if, you have your trials coming up. If the Supreme Court is seriously considering your case, they will often issue a stay of the underlying action so that it can facilitate their consideration of your appeal, your certiorari. And that can be granted by one judge, one justice. Each justice has a circuit, and they can decide on their own to grant a stay.
Yeah, and if you think about it this way, it's really interesting that they historically just have their particular area. So the First Circuit is Ketanji Brown Jackson, Justice Jackson. And now I will say this, on very steamy cases, when there are requests for stays, the justices are allowed to talk to each other. But think about it. If there are 9 justices, 9,000 cases, and those are just the writs, you have also the shadow docket, which have we covered? I think we've covered the shadow docket. We covered the shadow docket, which means those are done on the papers. So it's more than just 9,000 cases that are being filed to these 9 justices. That's a lot for all these justices to work through. That's why they have this dividing system where it's okay, these stays, we can talk to each other about it, but one justice is all it takes in order to grant or deny it.
And if you're in the United States, you may have noticed the Supreme Court's been very busy lately because there have been a lot on the shadow docket, the emergency docket, I think is what we like to call it. Alice, shadow docket.
I don't. It's been given the name shadow docket, which makes it seem all mysterious, but really all it means is it's not asking for. Well, sometimes they have oral argument from them, but, that's a whole other thing.
Yeah, but it's like, those are the cases they're rocketing up there. They haven't decided quickly. Supreme Court just decided one of those cases. And yeah, I mean, that's really just holding things where they are or quickly deciding a case. If a justice grants a stay, the rest of the court can vacate that stay. Or if a justice denies a stay, the rest of the court can say, hold on now, I think we need a stay, right? But Alice is right. There's often some communication there. If one judge is granting the stay, it probably means that some portion of the court is also interested in that. They talk a lot to avoid unnecessary waste of time because they are incredibly busy, and that is something that's going on. So in this case, she asked for a stay, and what happens?
Justice Jackson, I had no idea was part of the conspiracy, denied her request for a stay, which is really actually pretty shocking. It's not shocking at all.
But you're missing the key point. She went to Harvard.
Oh, of course. You know where Harvard is?
Massachusetts. It's in Massachusetts.
So this conspiracy has been just decades, generations in the making. In fact, this is like 12 Angry Men, except justices. This is 9 angry justices is what's happening right now. They had a mole all along, and they knew she was going to be appointed to the Supreme Court at the exact time when she would be taking over the First Circuit. Because, by the way, it's literally by seat. Like, historically, there's the seats. There's legacies of, like, whose seat it is.
Like, Justice Thomas is the 11th Circuit.
Right.
And I think the chief has the D.C. Circuit and maybe one other. Yeah. But yeah, they all have
it's based on like
circuits.
the seat. In other words, they don't like draw straws at the beginning of each year. It's based on the seat that you take and who was your predecessor. They've always had like the same circuits.
Yeah. So okay, now we're
okay. So she doesn't get the stay, but hey, stays. By the way, what do we look at when we're looking at stays? Likelihood of success on the merits. That's the biggest one.
That's
so likelihood of success. So if you're getting denied, that's not a great sense for you, especially because her trial really is about to start in like 48 hours. So boy, if there was ever going to be some sort of constitutional violation that the Supreme Court was going to right, this is the time for them to grant that stay, but they do not.
And I just want you to think about why this is important, because you could say, and some people have said, well, if they eventually grant her writ of certiorari, they could stay it then. They are not stupid. They recognize. Do you realize how disruptive that would be? Can you imagine if we're in like week 2 of the Karen Reed trial with 18 jurors seated here in this case, and then all of a sudden the Supreme Court's like, actually, guys, we're going to go ahead and consider this. So could y'all just take a break for a little while?
A little sidebar for like 8 months.
Yeah, because we're going to have oral argument.
We're going to have the sound machine on for about 8 months.
Yeah. So just, jurors, just don't talk about it to anybody. Don't mention this.
We're going to keep you sequestered for 8 months.
Yeah. Just
don't
crazy.
Watch the news about this.
So you would think, once again, that if there was any possibility of granting this, now would be the time to stay it. It was not stayed. So what happens next? So there's been no brief in opposition filed. There's been no brief in opposition ordered, which means we move to conference. If you file a writ of certiorari and you don't mess up the font or do it out of time or do it in some way that gets it automatically stricken from
by the clerk,
whatever,
the justices don't even look at it. It's literally a procedural thing.
Then it goes to conference. So like you've seen people say things like, the Supreme Court is poised to decide. No, this is going to conference like anything else. The way it works is they have a lot of writs of certiorari that have been filed.
In fact, like 8,000 to 9,000 a year.
Yeah, exactly. I'm going to go ahead and tell you, the justices do not read all the writs of certiorari. The way it works, they have a pool system. So all the justices, they have their law clerks who are smart, really accomplished lawyers who paid attention in Fed courts, and they have to review all of these. And the way it goes, they all go into the pool and they divvy them out. So you'll have a law clerk, like basically one like 26-year-old read Karen Reed's petition and wrote like a paragraph or two on it and then sent it up the pool, right?
To all the memos. Sent one memo to every justice so they're prepared without having to read her brief.
Exactly. And then
they can read it if they want to.
They sure can. And from that list, from all of that, what happens is a second list that no one ever sees that's totally internal of interesting cases they actually want to discuss in conference, right? So conceivably, Karen Reed's case could be one of those, in which case the justices would read the briefs and they would go to conference and they would say, hey, this is one I really feel like we need to take up. This is an interesting issue. It takes 4 justices to vote to take the case. So at this point, Karen is O for however many people have listened to this case, right? But if she can get 4 justices who at least think it's an interesting issue, maybe because, I mean, look, her best case is there are 9 justices who really want to write an opinion on how Karen Reed is completely wrong and they take the case. Like that is her best case.
That is her best case.
But most likely,
but by the way, they're really busy.
They are really
and
busy.
Even if they felt that way, they don't have time to deal with this.
This case is factually bad. It is a bad fact pattern. So the court, even when they see injustice, even when they see an issue they want to consider, they want clean facts. In fact, in a brief in opposition, if one had been filed, one of the things you would point out is how bad the facts are. Like, you don't want to get stuck in the facts that the defense didn't call for the jury to be
polled. That there was nothing announced, because there have been cases in the past that they've considered where it was a little murkier, right? You have the jury coming back and saying, we reached consensus of not guilty on counts 1 and 2. 3, we can't decide. And so then there is a mistrial, but it's on the record. It's very clear what those jurors were thinking before they ever left the courthouse. Here we have after the fact, after they've left. It's incredibly unclean. And there have been lots of cases written about how it doesn't count once the jurors leave. This is why you hear all those like clickbait articles where it's like, juror now completely regrets that they voted to convict Al Smith. That's because sure, you can have regret later on for lots of reasons. It weighs on your mind that you had to serve on a jury and put someone in jail. That is a real psychological effect that jurors have reported having after the fact. But that doesn't matter. No take-backsies is what this court has said for this very reason, because you leave the courtroom and guess what happens? People start hounding you. Journalists start hounding you. Defense attorneys start knocking on your door. You start feeling guilty because of all that pressure. That, by the way, is why often in these types of cases that are very high profile, you have sequestered juries, because you don't want them subject to the pressures that are not part of the evidence and not part of the case whatsoever. That's not justice. That's mob rule. So this whole thing comes back to not wanting mob rule.
Yeah, I mean, what you really needed here is you needed something like the foreman. They say they have a verdict. The foreman reads out guilty. Everybody starts to leave. All the other jurors are looking at each other, and one of them sort of raises their hand and says, actually, we all voted not guilty. I don't know what he's talking about. And the judge says, well, I'm sorry, the verdict's been announced. There's no changing it, right? Like, you really need almost something like that, because then the facts are very clear. It's a pure legal question. Once the verdict is announced, can you change it? And we don't have to worry about all this, like, were the jurors coerced? Were they influenced? Were they pressured? Was it media stuff? Like, you don't have to worry about all that. You just have a very pure question of law. They don't have that here. So that's going to be a problem. Okay, so conference. This case is scheduled for the August 25th conference. That is when it will be conferenced.
So one thing to note about conferences, all of this is available. So briefs that are filed, and if you go to supremecourt.gov, that's the Supreme Court's official website. It's a clunky website, but you can access all of the conference lists when oral arguments are. So in a lot of senses, it's way more transparent than a lot of the, say, state courts around the country. So you can see exactly which cases are listed for conference. This is not like some secret knowledge that only people on Twitter have. You too can have it at your fingertips.
So it'll be conferenced on Friday, April 25th. It probably won't even be discussed by the court. It'll just be on the deny list, and it will be denied on April 28th, because that's when the orders will come out for the April 25th conference. The very best case for Karen is that on April 28th, rather than deny it, they relist it. That means that they didn't get to it, or they're going to deny it, but some justice wants to write some sort of dissent, or they did discuss it, but you didn't really know what they want to do with it, so they want to hold it till later. If you relist it, it just means it'll go to the next conference.
This is like an
that
agenda.
is best
So
case.
there are entire podcasts who try to read into what relisting means. Sometimes it means a lot. And sometimes it means nothing, because you can imagine a case could be so meaty that there's a lot of debate whether we get to 4 or we haven't decided if we have gotten to 4. They want to decide and talk more about the case. Okay, relisted. So it's relisted because it's such a meaty issue. They really want to get to the bottom of it. Or literally it's so low on the list because remember those internal lists of cases they really care about? That's what they're actually discussing. So they maybe never even get to the list of straight denials or what have you. And the justices are like, I don't like just stroking a pen and denying things without having my eyes pass through them. At least just relist it. It's an agenda. Ever been to a meeting? If you don't get to an agenda item, what typically happens? You move it to the next meeting. Okay, we'll push that to the next meeting. That's what relisting could mean as well. In this case, if it's relisted, I mean, sure, maybe one justice is wanting to write some dissent to smack down Karen Reed.
Or even a concurrence. It could, I mean, a justice could write something to basically say, this case doesn't need to be considered, but in the future, judges and lawyers don't need to do this. Like, the defense should have done X, Y, and Z. The fact that they didn't is a problem and something that, that kind of thing, right? Like you could imagine that. Or maybe there is a justice who's like, hey, when the right case comes, we need to consider when a jury's verdict is final and what its double jeopardy effect is when later on jurors say that's not what happened. You could have that. You could imagine that, and that might be a reason to relist it. It will not be granted on the 28th. If they are going to grant, they almost always, like 99% of the time, relist at least once because they're still discussing it, right? So most likely, my bet is it will be denied on that day without comment. But if you see it relisted, that is what that means.
It doesn't necessarily mean she's going to get granted.
And if they do grant it, then I don't know exactly how they would handle that because...
Then would you file another stay?
Well, the problem with double jeopardy,
the court's grant?
The problem with double jeopardy, and the reason I think the court would have stayed this if they were even thinking about granting this, is the court has said that double jeopardy, the prejudice to the defendant happens when the next trial happens, right? So usually, even if you're claiming some sort of constitutional violation, like a motion to suppress fails, right? Well, you don't get to consider that till after the trial. You have the whole trial. If you're convicted, then you can challenge it. You can't challenge it beforehand. But the Supreme Court has said the fact of the second trial is a prejudice to you if a double jeopardy issue arises. So they would need to consider that. So I would think they would have to stay the case. They would have to stay the trial. And if they were to grant it in April, they would not hear the case
until October. At the earliest.
Yeah.
I think October is already filling up. And that's because the last cases are heard in April. They take a summer and then the term doesn't start until October. And so you can see cases that are being granted now. They won't be scheduled yet, but you can see how many grants they have and they tend to go in order of when they're granted. So there have been a number of cases, I believe, that have already been granted for the next term, as they always have.
And then you'll have oral argument. You have to have oral argument on it. And then you'll have to write an opinion on it. And the opinion won't be released until 2026.
Maybe even June of 2026 because they can release opinions all the way until June.
So all this to say, they're not going to grant it. It's not going to happen. It's silly that we're even here. I mean, this was a nice opportunity to talk about how the Supreme Court works is really what we're using this for. But the last trial is over. Okay, we are doing the new trial, and Karen Reed's got her jurors are selected as we record this next week.
And by the way, it's because the law is clear. There is no double jeopardy. There was a mistrial. There was no decision on any of the counts. And so therefore, this is not double jeopardy.
Yeah, this is like a dead on arrival, basically. If the Supreme Court had a dead on arrival list, this would have been on it.
Yes. And that is why. And by the way, must we go back to every single judge, state and federal, who has heard this, has summarily denied it without more word because they have too much to do. And this is peons. This is the smallest thing on their docket. Every judge is incredibly busy. This was not worthy of them to even have oral argument, for example, or to write an opinion about it because the law is so clear here. And so what you're going to see now, it's great press for them. They're at the Supreme Court. Even the layperson who doesn't know anything about law, not you guys actually know a lot about the law. Here, Supreme Court, this is big news. The Supreme Court's going to step in. This case reached the Supreme Court. You'll hear people say that all the time. My case went all the way to the Supreme Court. Like, what does that mean? Like, was it argued? Are you younger from younger abstention? or are you one of the 9,000 cases that file up there and then all get summarily denied?
Wouldn't that be terrible if we had to, for the rest of time?
The Reed abstention. The Reed abstention.
God.
I would insist if we had to do that, I would at least petition for it to be called the Karen. Just the Karen.
The Karen rule.
The Karen.
God. Yeah.
Craving your next action-packed adventure? Audible delivers thrills of every kind on your command, like Project Hail Mary by Andy Weir, where a lone astronaut must save humanity from extinction, narrated with stunning intensity by Ray Porter. From electrifying suspense and daring quest to spine-tingling horror and romance in far-off realms, unleash your adventurous side with gripping titles that'll keep you guessing. Discover exclusive Audible originals, hotly anticipated new releases, and must-listen bestsellers that hook you from the first minute. Because Audible knows there's no greater thrill than the one that speaks to you. Discover what lies beyond the edge of your seat. Start your free 30-day trial at audible.com/WonderyUS. That's audible.com/WonderyUS.
Ryan Reynolds here from Mint Mobile. I don't know if you knew this, but anyone can get the same premium wireless for $15 a month plan that I've been enjoying. It's not just for celebrities. So do like I did and have one of your assistants switch you to Mint Mobile today. I'm told it's super easy to do at mintmobile.com/switch.
Upfront payment of $45 for 3-month plan, equivalent to $15 per month required. Intro rate first 3 months only, then full price plan options available. Taxes and fees extra. See full terms at mintmobile.com.
This is a mini meditation guided by Bombas. Repeat after me. I'm comfy. I'm cozy. I have 0 blisters on my toes. And that's because I wear Bombas, the softest socks, underwear, and T-shirts that give back. One purchased equals one donated. Now go to bombas.com/Wondery and use code WONDERY for 20% off your first purchase. That's BOMBAS.com/Wondery and use code WONDERY at checkout.
Hopefully that clarifies it, because we've talked a lot of inside baseball. The only reason it's inside baseball is not because it's meant to be murky or whatnot. Those who practice in the Supreme Court bar are very familiar with this process. And you know who's now practiced at the Supreme Court? Karen Reed's lawyers. But the misinformation out there is being pushed, and they let it be pushed because the typical person does not practice at the Supreme Court. And so when they see things like, wow, it's relisted. Well, it's being conferenced. When you have a conference, that's a big deal. You know, I know because my kid's teacher called me in for a parent teacher conference, and that was a big deal because he bit some kid. No. All these cases are conference. These justices are extremely busy. Go to supremecourt.gov. Look at the types of cases they do take. See the types of cases that are being argued this term right now. And pretty quickly, a lot of them are very dry cases. You begin to see the types of cases that the Supreme Court is likely to take. And they are not typically to step in on one trial, one criminal case that hasn't even reached a verdict in order to smack down a conspiracy-laden jurisdiction.
And one thing we didn't talk about, which can happen, which didn't happen here, which I think would happen in a case where they were seriously considering this issue, is the Supreme Court can call for the views of the Solicitor General. So the Solicitor General of the United States. And this being a criminal case, something that would impact double jeopardy, this would be the kind of thing where you might see the Supreme Court do that. They obviously did not do that. And there's reason for that, once again. But yeah, I mean, Alice is right. And I think this is all part of the Karen Reed victim tour. Like, look how horribly she's been treated. All of her rights have been trampled. She's had to go all the way to the Supreme Court to try and vindicate her rights. Like, this is so terrible. Today, Karen Reed is in Vanity Fair talking about how she's OJ, which she is OJ, particularly if she's acquitted.
If she did it, she did do it.
If a white woman's OJ. I mean, that's what I've been saying the whole time.
Except I hope it will be a different outcome. That
yeah.
She will, in fact, get convicted and justice will be done.
And I'll just say this, and I believe this. The case was decided today. So they've got their jury. Case is over. We don't know what the answer is yet, but the case is over. Because if they have 12 jurors who are open to the evidence, she will be convicted. If there's some of these Karen Reed cultists on the jury, then it'll be a hung jury. Or if there are 12 of them, she'll be acquitted. But I mean, I feel strongly about that. I just think this case all comes down to, did they pick an open-minded jury? That's all they need, is an open-minded jury. If they picked an open-minded jury, they should be fine. But we'll see.
We'll see indeed. Well, I hope this was enlightening, at least. I know I talked really fast during this because really this is such a nothing burger that sometimes it's difficult to slow it down and explain why it is such a nothing burger. But hopefully this informs you as we head into the Karen Reed retrial. But if you have any questions about how the Supreme Court works, what printers you're supposed to use, and what color your brief is supposed to be, we're happy to answer those questions. You can email us at prosecutorspod@gmail.com. You can follow us on social media at Twitter.
Twitter.
At prosecutorspod. Or at Twitter. You could add us on Twitter. A lot of people at us. Instagram, you can join the Gallery Facebook group, where it's a fan-run group with some of the most intelligent true crime discussion that I've seen anywhere. But Brett, is there anything else you'd like to add?
Yeah, and I'll just point out, if you go to the Gallery, there are people who have questions about the Karen Reed case, who don't necessarily think she's guilty, who think she may be acquitted, who think maybe there's not enough evidence. That's fine. Like, I just want to point out, and I've said this before, I don't have a problem with reasonable people who are not insane, who think that Karen Reed might be innocent. But I do have a problem with people who have essentially turned this into some sort of religion in which she is a saint and Turtle Boy is her prophet, and there's this massive conspiracy, and all these people are involved, and from judges to all the police departments. Like, those people, I'm sorry, I have no respect
The growing
for you.
list of conspiracy
It's insane.
Well, it's demeaning. It's incredibly demeaning to the layperson that you think we are that stupid. That all of these judges, that all the reporters, that the printers for the Supreme Court probably slipped in a footnote that said, justices, remember the code word from when you went to Harvard, do not grant the stay. No, that's not what happened. It insults the intelligence of people, and it sucks up the true crime news that could be rightfully spent on someone who needs it, rather than this case, which is tired and old and the facts are there. Now, the jurors may have their minds made up, but then they lied during jury selection that they don't have open minds, because the facts of this case is incredibly clear. We're not going to go through the Karen Reed episodes again. You can go listen to them if you'd like, but they are there. And hopefully this is the end of this, because like we've always said with this case, with the Adnan Syed case, with Scott Peterson, we have limited time, all of us. There is limited coverage that we can consume. Don't give this additional time and energy to these cases that are incredibly clear-cut, are not instances of massive government or police conspiracy, but there are people out there who could use eyes on their case. Let's turn our attention there, is all we're saying.
Having said that, we're probably going to do like 8 more episodes on this case before it's over, because you guys want to hear about it. So we'll probably do some sort of, weekly or bi-weekly or something recap on what happens. I mean, I don't know. I hope it's different from the first time. I think it will be. I think the focus is going to be a lot different, but we're just going to have to see. I don't know.
We'll have to see. We'll have to see.
All right, Alice. Well, fun as always.
Fun as always. Do we want to answer a question?
Oh, sure. Let's answer a question.
Since we're all like hot to trot about this anyways.
Why not?
This case does get me hot to trot.
This is another one. I told Alice, I was like, oh, this will be a short episode. We'll just talk about Supreme Court.
When you said that, I almost laughed, but I just was like, I'm just going to let Brett think this is a short one.
Yeah. Yeah. Don't even need an outline to go on forever. Okay, let's see. This is Legal Briefs questions, right?
That's right. Okay. If you leave a 5-star review for Legal Briefs or Prosecutors, you get to ask a question, any question, and we answer it. So it's a lot of fun.
Okay, so Mick Waves wants to know, what do you think of the progressive prosecutors popping up on the state side around the country? I don't like people who call themselves progressive or conservative prosecutors or liberal prosecutors, anything like that. Like, I feel like you've started on the wrong foot. Like, you're injecting politics into a job that should be non-political. I mean, your decision on whether or not to prosecute someone, whether or not to seek an indictment, should be based on the facts, the law, and all of that, not on your political perspective. So I'm not a huge fan. I get the idea, I guess, to be more like sensitive to various issues, but not a big fan of, defining yourself as a prosecutor by your political position.
Yeah. Well said.
That
We
was
always
easy.
say justice is supposed to be blind, right?
It's
Lady
supposed to be
Justice has
blind,
blindfolds
exactly.
over her eyes because justice is meant to be blind. Listen to Ivan Bates's interview. I think that was one of our best interviews here on Legal Briefs. And the way he talks about the role of a prosecutor, I think, is something that really resonates with us, but shows you that it shouldn't be about politics. Obviously, most prosecutors, I think, in most jurisdictions are elected. So there is that element of prosecutors, but it should be to do your job to uphold the rule of law and to treat all people equal under the law. So the same two people who look different, come from different backgrounds, what have you, one has money, one doesn't have money, think of all the different ways they can be different, both break the same law, the law is supposed to treat them the same. That is the ideal that we have in this country. So if you want to talk about that, we can certainly talk about that.
It's a problem if the law is applied differently based on the political party of the person in office. I mean, then that sort of undermines
Truly
everything we
not
believe about the
justice.
rule of law. Yeah. Okay, so Larissa wants to know, what aspirations do you have for the future? Are you working toward bigger career goals? I don't know what Larissa's trying to say about our current careers, but
Are you saying my current career is not very good? Which career? Which one?
I'll just say
we have no
this.
aspirations ever. I mean, Brett
Yeah.
played Guitar Hero through Fed Court. It's the most important class in law
It's
school.
true. It's true. I will say this about my career. I have never had career goals. Like I've never taken a job based on the next job. So I've never taken a job based on, the only job I might have taken based on money was the first job I had when I went to a law firm.
Which
Okay?
is
I mean, I
fair
was just out
because
of law
like
school.
everybody
Yeah.
took that in order to pay off law school debt.
But I also wanted the experience too. But yeah, I mean, I knew I wanted to be a lawyer. So I guess going to law school was a career goal. But then after that, it's always just been, is the job interesting? Is it something I want to do? You know, I mean, I've been all over the place. I started at a private law firm, and then I was clerking for judges. I did a couple different judges. Then I took a complete left turn, went to work on a presidential campaign, worked in the Senate. And then I was like, now I'm going to go back to state. I'm going to go to state and worked in the Solicitor General's office and did all that stuff and filed these weird briefs with the weird margins. And then DOJ, where I've been since 2017. So, but none of that was ever like, if I do this, you know, if I go to this job, then I can do this job, then I can do that job. So I've never done that. It's all just been sort of whatever popped up. And that's still where I am. And I wouldn't necessarily recommend that. I mean, maybe that isn't a very good way to order your life, but it's worked out for me.
We can't all get B pluses by playing Guitar Hero all day long. No, I totally agree with you. I will say there are plenty of law students and plenty of people that we both went to law school with who thought about every single social media post they put out there because they want to make sure they get through a Senate confirmation hearing later on in their life, or they only take this job because it's the shiniest gold star you can have. For me, the fact that I ever even became a lawyer is like shocker of shockers, right? That there was no world in my life where I was going to become a lawyer or even go to an Ivy League. So the fact that I'm a lawyer is shocking. I've personally never taken a job thinking about the next step. I've taken a job because I was like, wow, this is something I want to do now. And in fact, so judges aside, because you certainly apply for clerkships, but you apply to lots of judges. So, you know, I was a little bit targeted. I knew I wanted to go back to Texas, so I applied to Texas judges. But other than that, it was like, I just want to work with a judge because that's a great training ground, learning experience. I essentially have applied to like 2 jobs, really. But I've had like 12 jobs. And that's because doors opened once I was there. So I said yes and walked through those doors. I didn't create those doors. They didn't open because of anything I did. They were put before me at certain times in my life. Also, always at the most inopportune times. I think I've said this before, maybe can encourage some of you. Each one of the times that I've been pregnant, like very pregnant, you know, because I get very pregnant, as I guess everybody does, I've gotten a promotion. And those are typically when you probably don't get promotions because, you know, you're about to be out on maternity leave. Some people choose to step out of the workforce after they have, you know, X number of kids. And so I say that because they would not have fit any sort of plan. Like if I were like family planning, let's make sure I only have kids after I've accomplished X, Y, and Z, I wouldn't have gotten a lot of the opportunities they ultimately did. All to say is I planned nothing in my career, and I still have planned nothing in my career, and I don't know what I want to be when I grow up.
Well, I mean, we would not do this podcast if we were planning our career.
In fact, you shouldn't do this podcast if you want anything to do
Prosecutors
in
don't
a
do
legal career.
podcasts.
No,
I mean, there's a reason
lawyers
all the
don't do
YouTubers are
podcasts.
defense attorneys, like, and we run into people all the time and they're like, I can't believe you did that. Or I can't believe they let you do it. Or why would you,
Or that you keep doing it.
Yeah, because who knows, like, trouble we get into with this podcast, right?
Well, think about how selective people can be, and they can clip, like, 3 words that I say, and I meant to say, like,
She knows this from
I
experience.
love rule of law, and instead you just say, like, I love rule,
I'll give you an example
like, wow,
of this.
She's a dictator.
So, we're doing the West Memphis 3 while we record this, and somebody on Instagram was like, they're obviously closed-minded because at this time stamp in episode 2, they said they did it. And they put that in quotation marks. And I was like, you were a complete
They cut out
idiot.
if they did it.
No, it wasn't that. It wasn't even that. It was, I was talking about how a lot of times when you're researching a case, you'll come across something and you'll be like, wow, they did it. And they were like,
Are you kidding? It was a
I'm
quote.
not kidding. And they're like, see, they said the words, they did it. So they've already made up their mind. It's like, but that's exactly right. You can do that. And then you post it on the internet or you clip it and you throw it in your, your questionable podcast. And you're like, see what they're doing? See how biased they are? And then people who
take
are
out
gullible,
every single giggle that we do and then splice it in with every time we say, and they were murdered. Ha ha ha. Literally, that's like
With the
half of
laugh
our
thing all the
1-star
time.
reviews is they laugh about murder victims. And I'm like, I mean, that's selective hearing.
Yeah. But that's easy to do. So, we wouldn't do this, but like I said, it's all going to work out. So that's our philosophy.
If we had a life coach or a professional coach who was like, this is how you advance your career, I bet you the number one thing they would tell us is to not have a podcast.
Yeah. And you see that a lot. And frankly, I mean, I got a lot of friends who are doing great things and have risen to great heights, but man, they have boring lives. They've really just lived their whole lives like making sure
like
that
they don't post pictures.
Yeah.
They don't write anything publicly. They, whenever asked a question, like in a public forum, they're like, I have no views of my own.
Yeah.
Those are people I went to law school with.
Who wants to
because
live like that?
No, we're fiery. We can't help
So,
it.
yeah.
We're fiery.
That's a long
So,
answer to
sorry,
a short
back to the
question.
original question. Do we have greater aspirations? I guess the answer is no. This is my greatest aspiration.
I have no idea. Yeah. I mean,
I don't know what 5 years down the. Can you believe we've been doing this podcast for 5 years?
I can't believe it.
I don't know what's going to happen in 5 years or 10 years. I don't know what's going to happen in like 5 weeks. My goodness.
I don't either. I mean, who knows, right? So anyway, so that's where we are.
Those are great questions. Thank you. Well, guys, if you leave 5-star reviews, you too can get us to get all excitable and talk about things other than just Karen Reed. Well, Brett, this has been fun. I'm so glad this was a short episode. That was sarcasm. But what can I say? We love talking to you guys. We love talking to each other. Let us know what you think at prosecutorspod@gmail.com. Let us know what you want to hear about. If you don't want to hear about Karen Reed, suggest some other topics, and we are happy to cover them. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Okay. Perfect. I'm going to go live. You care if I go
Okay.
live?
Yeah. I should really just get rid of the sound thing in the back. I don't think it does anything, and it causes me a lot of headaches. Hold on.
Okay. Weird. The sound and everything's okay, but the actual
acting?
website's being weird. Let's see. Let's try it here. Ah, there we go. Just had to resize it.
See what's screaming free all month long during Pluto TV's April Ghouls. Get your heart pounding with nightmare-fueling classics like Insidious and Bram Stoker's Dracula. Or test your nerves with haunting hits like Urban Legend and Don't Be Afraid of the Dark. Pluto TV has hundreds of channels and thousands of terrifying movies, live and on demand. Download Pluto TV on all your favorite devices and start streaming now.
Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's join, MOCHI.com with promo code AUDIO40.